Hi, everyone. Thank you for coming today. My name's Craig Pursehouse, and welcome to this talk hosted by the Centre for Private Law and the Faculty of Law. We're very privileged today to have one of the leading torts scholars in the world, Professor Roderick. Professor Roderick Bagshaw is Professor of Law at the University of Oxford and a fellow in law at Magdalen College. And he is the co-author with Nicholas McBride of McBride and Bagshaw's Tort Law, which is a textbook that if any students are in the room, they will be familiar with, and also one of the editors of Clark and Linsalong Torts, the leading practitioner work, as well as many other publications. Today's going to be talking to us about coordinating private law accessories. So thank you, Roderick.
Thank you very much. When it was announced by the Centre of Private Law, and very grateful for the invitation, that I was speaking on this topic, one of my Oxford colleagues said, well, sounds like you're going to talk about handbags. And of course not. You know, I'm not going to come to Hong Kong and talk about fashion, because you're well known to be the most stylish law school in Asia. Nice crepes. Obviously, though, as a nerdy private lawyer, I have spent a lot of time staring at other people's shoes. But no, what I'm really going to talk about is I'm going to talk about liability of accessories. And accessories can be liable in tort law for procuring torts, assisting other people to commit torts pursuant to a common design, can be liable for tort of unfair means conspiracy. And then there's liability in equity for dishonest assistance and the like. So it's those sorts of liabilities that I'm talking about. And what I'm mainly going to talk about is how well do those doctrines fit together, in particular in light of a Supreme Court case, the Lifestyle Equities and Ahmed case. Don't want to talk about the Lifestyle Equities and Ahmed case in terms of talking about its facts, but talking about how it has clarified in some way some of these liabilities and how they now fit together. And one of the reasons for doing this is in order to talk about two bigger topics. Topic of whether there ought to be general principles of accessory liability in private law, and the always coming up again and again topic of whether the tort of unlawful means conspiracy ought to be demoted from its current high status of being an independent tort down to just being another form of accessory liability. So those two big questions are lurking in the background, but the main question is about how things fit together. The first important thing that was said in the Lifestyle and Ahmed case was that liability for procuring a tort was based on the same underlying principle as liability for procuring a breach of contract. So there was a proposal made there that liability for procuring a tort, same underlying principle as procuring a breach of contract. But then liability for procuring a tort was distinguished from liability for assisting somebody else to commit a tort pursuant to a common design. So the two important moves being made there, that procuring a tort was being based on the same principle as procuring a breach of contract, and assistance liability was being separated off from procuring a tort. And in terms of identifying some differences that between procuring a tort and assisting a tort, that Lord Leggett in the Lifestyle Equities case, that almost all the quotations I put up on the slides are going to be from Lifestyle's Equity, and I've usually just given the paragraph number rather than giving you the full reference each time. The two differences he came up with, that he said that only the assistance liability, assisting somebody else to commit a tort pursuant to a common design, only that required a common intention. That if you were going to be held liable for procuring a tort, you didn't have to have a common intention with the person who you were procuring to commit the tort. Second distinction that he drew between the two was that he said that procuring a tort required a different form of causation from the assistance liability. So he said that the assistance liability didn't require such a strong form of causation, that it required a form of causation that could be satisfied by making a kind of more than minimal act of assistance towards the tort being committed. So he drew those two distinctions. There was one important distinction that he didn't draw, a non-difference. He said both of these forms of liability depended on there being knowledge of the essential facts which make the act being procured or assisted wrongful. And that was the case even if the tort was one of strict liability, that you still had to have knowledge of those essential facts. And he explained why it was essential facts that you were looking for in terms of the principle that ignorance of the law is no excuse. And so, well, I can read it. You could probably read it at the same pace. Why don't I read it? In accordance with the principle that ignorance of the law is no excuse, liability cannot depend on whether the defendant knows that the act done by the primary wrongdoer is against the law. When courts refer to a requirement of knowledge that an act is wrongful, they must generally be taken to mean not that knowledge of the law is required, but that the defendant must know the essential facts which make the act unlawful. Okay, so general theme is about how do these forms of accessory liability fit together? And we remember back that Lord Leggatt has said that procuring a tort liability is based on the same principle as procuring a breach of contract. That then leads us to some difficulties, because there isn't straightforward and separate liability for assisting a breach of contract. On the tort side of the line, he's drawn a nice distinction between procuring a tort and assisting somebody to commit a tort pursuant to a common design. But on the contract side of the line, there is some liability for assisting in a breach of contract, but it's rolled into the tort of procuring a breach of contract. And that part of procuring a breach of contract that involves assistance doesn't appear to require a common design, at least in the sense that Lord Leggatt seemed to have in mind. Maybe it does, but doesn't seem to. But the causation difference is even stronger, because the assistance form of procuring a breach of contract seems to be available principally in situations where somebody would not be able to break a contract without assistance. So, for example, in a case like the North Amber case, the contract concerned was an exclusive dealing contract. You can't break a contract to deal exclusively with the claimant unless somebody else comes and deals with you in such a way that breaks the exclusivity deal. And it seems to be in those cases that there's potential liability for assisting in a breach of contract, where there would be no possibility of breaking the contract without the assistance of the person who's going to be held liable for assistance, albeit under the label of procuring a breach of contract. So begun to get a bit of a problem with regard to fit in terms of the equation between procuring a tort liability and procuring a breach of contract liability. Though actually the tensions get worse when we look at the issue of the state of mind. Remember that in procuring a tort, Lord Leggatt is asking for knowledge of the essential facts. Though when we look at the procuring breach of contract cases, then, well, if we look at the Hong Kong case, which I'm a complete coward, so I'm going to call it the Eaton Properties case, what's said there is that the alleged inducer must know not just the facts, but their legal consequence. And that wasn't something that Lord Sumption was just coming up with off the bat. He was taking it from longer quotation from Lord Hoffman in the OBG case. that the suggestion that you have to actually realize that what you're procuring is going to involve a breach of contract. And so it appears that it's not just a simple kind of knowledge of essential facts, unless facts is given an unusual meaning on the procuring breach of contract side of the line. Now, this, of course, suggests that if we're thinking of that general question about should you have a general principle of accessory liability, well, what are the alternatives? One of the alternatives being put forward by Pauline Ridge and Joachim Dietrich is the idea that what is the wrong matters. So that it might be that it's a breach of contract that's being procured, you have a different set of accessory rules than if it's a tort that's being procured, because what is the actual wrong makes a difference as to what are the necessary accessory rules. If we're going to come up with an explanation as to why that might be the case, then a way of thinking about it might be, well, that there's some things, some forms of behavior that are prima facie wrongful, that making physical contact between your fist and somebody else's face, well, if you procure somebody to do that, one might say, well, you're procuring them to do something that's prima facie wrongful. But procuring a breach of contract, what you might be procuring them to do is to sing at the Royal Italian Opera in Covent Garden. There's nothing prima facie unlawful about procuring somebody to sing at the Royal Italian Opera in Covent Garden. It's only unlawful if special conditions pertain, such as the person has made a contract that they will sing exclusively at Her Majesty's Theatre, Drury Lane. And it's only if those special conditions can pertain that it's unlawful. And so it may be that when you've got one of these wrongs that is dependent on special conditions pertaining, that what you might need by way of knowledge of the essential facts has to change because of these special conditions being essential to the behavior being wrongful. Different where what you're procuring is something that is simply prima facie wrongful in almost all circumstances, like bringing your fist into contact with somebody else's face. We can make it's actually something that Lord Legate himself picks up on in the case, that one of the issues that's at stake in the case is, well, what about directors who bring about torts or breaches of contracts by their company? It's got a difficult issue of accessory liability, where the director of the company makes the decision that leads to the company breaking the contract. Is the relationship between director and company such that it has an impact on whether this is an instance of the tort or the liability for procuring a tort? And in that circumstance, there's an English case, Said and Butt, that suggests that, yes, it does make a difference that there might be some sort of exception from liability for employees bringing about breaches of contract by their companies, directors bringing about breaches of contract by their companies, as long as the person is behaving in a kind of responsible way rather than pursuing their own ends. Now, Lord Legate in the Lifestyle Equities case is going to defend that rule, but he's going to re-explain it. So he's going to say that, yes, that's true, that there is a special exception with regard to a director procuring a company to break a contract. But he's going to say that the special exception is based on, long quotation that I've made very colorful on the slide, that it's based on a social understanding. So probably you have to read it through and then have a go at summarizing it, that when an agent, and so this is what he's going to bring the director under and the employee under, when an agent acting as such makes a contract, the normal understanding is that the agent assumes no liability towards the other contracting party. Only the principal does. Well, so far so good. Similarly, the normal understanding is that if the agent causes the principal to break the contract. Only the principal will incur liability to the other contracting party and not the agent. So the first bit, it's a fairly basic idea that when the agent negotiates the contract, the person who's signed up has only got a contract with the principal, not with the agent. And then he's flipping that and saying, and when the agent brings about the breach of contract, similar expectation that it's only the company that counts as having broken the contract. You don't also have a claim against the agent. It would be inconsistent with that understanding for the law of tort to make an agent who, acting within the scope of their authority, causes or procures a breach of contract by the principal, liable to compensate the other contracting party for loss resulting from the breach. That's because the same norm or understanding that, unless otherwise specifically agreed, only the contracting parties themselves will be liable in the event of a breach of contract, entails that if a party wants a right of recourse against an agent of the other party, they must bargain for it. So what we can see there is a difference being made between procuring a breach of contract, where this special understanding applies, that if somebody procures a breach of contract whilst acting as an agent within the scope of authority, you don't get a procuring breach of contract claim against them, and situations where they procure a tort or the like, where unless it's one of those special torts, which depends on there being an assumption of responsibility, in which case it might track the contract rule, but if it's just an ordinary tort, like an intellectual property tort or a punching somebody in the face tort, quite hard for a company to punch somebody in the face, but the suggestion is that in those cases you wouldn't have this special rule. So even Lord Leggatt is drawing some sorts of distinctions with regard to accessory liability according to what wrong it is that you're dealing with. Now, this doesn't just apply as between torts and breaches of contract, that if we bring in to the room dishonest assistance, what we find is that accessory liability doctrines that are based on special conditions, so things like breaches of contract, also possibly breaches of trust, breaches of fiduciary duties, bring in the issue of risk. What exactly does the contract require somebody to do or not to do? What exactly does the trust require? And the like, that there's interpretation issues and therefore there's a risk. Is this thing that I'm about to procure going to be a breach of contract? Is it going to be a breach of fiduciary duty or the like? And then you need rules about, well, what are we going to do about that risk where the procurer isn't absolutely sure which side of the line it falls on? In the procuring breach of contract case, then this case, English Court of Appeal called Allen and Pollock, where someone's going to possibly procure a breach of contract, take legal advice. Legal advice is probably that contract is not enforceable. Court of Appeal says, well, if you procure breach of contract of a contract that's probably not enforceable, but that's wrong, was enforceable, you haven't committed the tort. So they say if you got the legal advice that it was probably not enforceable and you procured the breach of it, you haven't committed the tort. Of course, the person who's broken the contract, that they've broken the contract, the fact that they'd got similar advice doesn't help them. But in terms of risk, we're saying the person who's made the contract is in a different position with regard to that uncertainty than the person that's procuring the breach of contract. Court of Appeal leave open what the position would be if the legal advice had just been, it's arguable that the contract is unenforceable, and you press ahead and procure the breach of it. Slightly different answer gets reached in the dishonest assistance setting, at least the editors of Lewin on trusts, that they're different state of mind that's required, looking for dishonesty. So if you've assisted in the breach of trust, assisted in the breach of fiduciary duty, it's going to turn on, was that dishonest assistance or not? editors of Lewin on Trust say, well, if what you're in a situation where you get advice might be a breach of trust or might be breach of fiduciary duty, is it dishonest to push ahead and assist nonetheless? That they say, well, it kind of depends on what it would cost to eliminate the risk. If you're going to need advice from a KC in order to be sure whether this is going to be a breach of trust or not, and all that's at stake is £500, maybe not dishonest to push ahead and potentially assist a breach of trust. On the other hand, if it's £500 million, maybe you've got to take the advice from the KC before you push ahead and assist. And their suggestion is that, well, that's an appropriate approach to managing the risk in the situation of assisting in breach of trust. Slightly different approach from the one that's been outlined in terms of assisting in a breach of contract or procuring a breach of contract. Now, in terms of the sort of general principles of accessory liability question, the question that's obviously lurking is, might it actually be sensible to have different rules about who bears the risk of interpretation problems as between assisting in a breach of contract and assisting in a breach of trust? If we thought it might be sensible to have different rules, it's obviously going to weigh against there being general principles of accessory liability. It's not just the risk-taking where you might have different rules. Another situation is where you're dealing with indiscriminate assistance. People who assist in ways where this would be useful for quite a lot of different types of law breaking. And I'm not sure what sort of law breaking is going on. Well, should that be actionable? And it's obviously not what's set out in Lord Legate's notion of the necessary state of mind, knowledge of the behavior that's being procured being a tort, the essential facts that make it tortious. Well, what if you don't know the essential facts that make it tortious? Instead, you've just got a sense that what I'm doing is the sort of thing that could assist all sorts of different types of law breaking. Now, in the case of the breach of or dishonest assistance in breach of trust, that Lord Hoffman in the Twin Sector case suggests that he has little sympathy for the kind of indiscriminate assistant and takes the view that it would be enough if you knew perfectly well that you were helping to pay away money to which the recipient was not entitled, and exactly what form of breach of trust or the like had gone on beforehand. Not too much interest in that, enough that you've got a general sense. That if I'd have written the paper finally before I did the slides, then I'd have put a contrast here with unlawful means conspiracy. Unlawful means conspiracy, there's discussion in the case last year about conspirators who join indiscriminate conspiracies. So they join conspiracies to cause harm to the claimant by the use of unlawful means, but they're not absolutely sure what sorts of unlawful means their co-conspirators are going to resort to. And the question arises, well, does that matter? Is it enough that you've just got a kind of general sense of what sort of unlawful means that they're going to use against the claimant? And one can imagine you then get questions that arise about, well, what if one of the conspirators chooses to resort to a form of unlawful means that never crossed your mind that they might resort to? You've joined a conspiracy to harm the claimant's interests by unlawful means, that you clearly haven't kind of drafted the conspiracy in such a way that people feel forbidden from using these unusual methods if they resort to the unusual method. Or does that mean that you can say, oh, no, I'm not a conspirator anymore, or I'm not actually liable anymore, or at least I'm out of that bit in terms of the damage caused? So we get these kind of problems, and again, the question is going to arise in terms of whether you want to have general principles as to whether it's okay to have different answers with regard to indiscriminate assistance according to what sort of wrong we might have in contemplation. That wrongs involving dissipating of money, we might think you've got a different approach to than certain other types of wrong. Unlawful means conspiracy. We bring it in here mainly because I put on the abstract that I was going to talk about unlawful means conspiracy, and I'm aware that there's certain people that just go and move around the world looking for papers on unlawful means conspiracy. It's their thing. Yeah, no, John, don't out yourself as one of them. So unlawful means conspiracy. That one of the things that arises here is that the existence of the equitable liabilities for dishonest assistance and the like, that the shadow of that has led to the view that you can't have common law liability for procuring breach of fiduciary duties or assisting in a breach of fiduciary duty pursuant to a common design. You can't have those kind of cocktail form accessory liabilities. You've got to go on the equitable side of the line, and equity handles the conditions of liability rather than you being able to put the equitable wrong into a common law form. That obviously raises the question, okay, so what about unlawful means conspiracy? Can you have an unlawful means conspiracy where the unlawful means is the equitable wrong, is the breach of fiduciary duty, or is the breach of trust, or the like? Well, at the moment, cases are being argued and aren't thrown out of court where they rely on that sort of cocktail. And we might sort of ask, well, why is that? Is it because the intention to injure the claimant in some way changes the nature of the beast, so that it isn't quite the same sort of accessory liability anymore, but is instead a wrong of joining a gang that has the purpose of injuring the claimant using a particular unlawful means? That hints that it's not straightforward accessory liability might include that, think about the causation question. That Lord Legate was suggesting that you had a different causation rule with regard to procuring a tort and with regard to assisting other people to commit torts, but there was a causation requirement in both of them. But we might think, well, if you've joined a conspiracy to use unlawful means, is it necessary to show the unlawful means would not have been used if you hadn't joined the conspiracy? Is it even necessary to show that your joining the conspiracy has increased the likelihood of the unlawful means being used, or that you've in some way assisted the unlawful means being used? I'd suggest the answer to those questions is no, that there isn't a requirement that your joining the conspiracy increases the likelihood of the unlawful means being used, that you're being found responsible for something else other than as an accessory to the unlawful means that have been used. There are lots of awkward questions about unlawful means conspiracy, apart from the question about the equitable wrongs, which I left open. That there's questions about whether the conspirators have to know which means are going to be used. We talked about that in terms of indiscriminate conspiracies. Do they have to know that the means are unlawful? And their Court of Appeal in England, at least, has held that the answer is no at the moment, that it's just you have to know the essential facts. There's a question about whether conspirators actually have to do positive acts in advancing the conspiracy, or whether you can have passive conspirators, conspirators who just sort of lend their moral aid or something by joining the conspiracy, but don't actually in any active way advance the causing of harm to the claimant. There's actually cases going both ways on that. That there's quite a lot of cases that say you've got to have acts of participation, but other judges have gone through and have found instances of mere passive support giving rise to liability. And as I suggested, that there is the causation question, which currently doesn't appear to be treated as a significant hurdle. So there's lots of questions arising under unlawful means conspiracy. And clearly, if you're going to have general principles of accessory liability, and you were going to try and absorb unlawful means conspiracy into that general model, these questions would have to be answered in such a way that they aligned with the answers that were being given in terms of the procuring liabilities. If you're going to have the general, well, you'd have to have consistent answers within the general principles. There we are, that we get to the end. We've got the question lurking. Should there be general principles? That the obvious advantages of having general principles is it'd be nice and simple. And those who push the simplicity also seem enthusiastic about narrowness, that they would like the accessory liability to be both simple and narrow. And narrowness is often put forward as being an actual goal, that narrowness, it's suggested, is desirable because accessory liability is presented as something that gives claimants an extra defendant. They got the primary tortfeasor, got them already, and then accessory liability gives you an extra person to sue. And so it's thought, you know, that the gift shouldn't be too generous, that you should only get the extra person to sue in a narrow range of circumstances. Of course, there's an alternative way of looking at accessory liability, and it's to think about it in terms of reducing overall risks. And there we draw the parallel with something like vicarious liability. In vicarious liability, also a situation of people being held liable that didn't do the wrong themselves, seen a general expansion of the liabilities in order to bring home to parties other than the direct wrongdoer their responsibility for controlling certain types of risk, it being better to target that person if you want to control this sort of risk. And my view is that accessory liability fits alongside vicarious liability in that world of working out what sorts of liabilities are best tailored to deal with the risk. Of course, that means that I haven't talked about fashion, but I have ended with the point that you shouldn't pay too much attention to labels. That's it.